You want us to switch, Judge?
No, that's fine.
May it please the court, Robert Emanuel Shepard and Condon here on behalf of Gator Boring. I would like to reserve 5 minutes. This is the first of 2 related appeals that you're going to hear this morning that are interrelated as to parties and facts. But I'll focus here on the first argument, that is...
And as we all know, the records have been, for purposes of appeal, the records are the same, so those have been shared with your case and the other case that's scheduled as well. Very good, sir.
Thank you very much, Judge. Your Honor, I first want to address the court's granting a motion for summary judgment in favor of TECO on the various tort claims that Gator Boring brought against TECO and as to which the judge granted summary judgment. That is a decision that you reviewed de novo, and we believe for several reasons the court erred in granting the summary judgment. I want to start with the concept of what was not disclosed to Gator Boring that we believe was important and prevented the granting of the summary judgment.
And certainly that's what we're here about. But before you talk about what wasn't disclosed, you're going to have to address the contract that says investigating the site was your job, and they didn't have to tell you anything.
Well, Judge, I disagree in this regard. If you look at the contract incorporated a certain ASTM regulation. And the ASTM, which is a part of the specifications of the contract, required that the owner perform certain geotechnical review, obtain reports, and then share them with prospective bidders. And that was a contract requirement. And if you look
at the time of the bid documents, they gave you everything they had.
Your Honor,
some things were required after the fact, possibly, but at the time of the bid documents, they gave you everything they had. The first report, the core borings that had been completed, none of which were on the private property, which they didn't have permission yet to get on, but you got everything they had at the time.
Well, Your Honor, that is correct as to the initial bid of the project. But my client, Gator, although it bid on the initial contract, it did not receive that subcontract from Westra. Several months later, Westra came back to my client and said, okay, we'd like you to bid on the project again. By that time, the access to that site had been obtained the previous December. The additional bores had been obtained. A second engineering report had been prepared by TECO's engineer, and TECO was aware that that report existed. TECO's engineer had also said at the time access was obtained to that site that these additional bores were critical.
But you're a subcontractor to Westra, right?
That is correct, sir.
You're not in privity with TECO, right?
Well, but Your Honor, the general contract was incorporated by reference into our subcontract. So I believe that required TECO to share with Westra the second report once it was received, and also that Westra had an obligation to provide us with all the material information in their possession at the time of our second bid.
The second report was generated and existed 3 months after the contract was signed.
After the prime contract was signed, that is correct, Your Honor, but the timing was prime contract is signed, and at that time only the first report existed.
And the second report really didn't have anything materially different about the existence of rock right in the key area where you were going to bore. It talked about, and the other difficulty, of course, I have with this case is everybody knows there's rock in Polk County. That's why there's mining in Polk County. So the second report didn't give you any information that there was any expectation of rock in the path of the drill, but it indicated there's rock in the general area. Well, you didn't need the report to know that.
Your Honor, I disagree.
Someone as dumb as me knows that.
If you look at the first report, the first report concluded as follows. The majority of the borings performed did not encounter any deleterious material, shallow rock formations, or any other conditions that would make conventional excavation techniques, jack and bore, or directional drilling operations difficult. That's the first report. Now here's the conclusion of the second report. Of particular note, the boring conducted at the western side of the north prong of the river encountered weathered limestone below 35 feet, which is significantly harder than most of the soils encountered on this project.
Because I know what the report says, because I've read it, but I appreciate that. You talked about the north prong of the Alafia River. Where was this rock encountered?
Well,
What part of the Alafia? It was under the Alafia River. What
no,
part?
it was adjacent to it, Your Honor, on the DSE site.
Was it on the North Fork or the South Fork?
I think it was on the South Fork, Your
I
Honor.
thought it was too, so why do we care what's on the North Fork?
Well, because this was the closest area in which bores were taken as it related to where the direction of bore was actually going to occur. And what the report concluded, directional drillers will have to consider the harder material that will be encountered when drilling is conducted in this area.
But going back to what Judge Moore said, wasn't there testimony that that was about, is it 1,000 feet, or I've heard 3 football fields away from the actual site?
Your Honor, it is not exactly on the site. It was the closest to the site where bores were done. At the time that access was obtained to the DSC site, and these additional bores were getting ready to be done, TECO's engineer said these additional bores are critical. That's what he said in an email. These are critical. Then these bores are done, they're put in the second report, and the second report is never shared with Gator Boring until discovery in this case. Never shared. And it is undisputed that Ms. Lyons, the president of Gator Boring, has testified that had she been provided with this second report, she never would have entered into the contract with Westra. It is also telling, I think, that a few days before Gator provided its second bid, there was an email from TECO's engineer to Westra engineer or project manager warning that the drilling contractor should be informed to anticipate encountering rock. Interesting, that's in a chain of emails that comes from TECO's engineer to Westra.
But the contract you signed indicated that this information might not be available, and you have to visually inspect it as best you can without encroaching on private property and make your call.
Well,
You took a risk and signed a contract with what the information that was available at the time, and the contract said you're going to have to take this risk.
Well, Your Honor, I disagree on this report. At the time Gator did its initial bid, you are correct, access to the DSC site was not available. And everyone was directed, okay, you don't have access to this site. You're going to have to prepare your bid based upon the information you have, which is the first report and being able to visualize from as close as you can get. Now, fast forward to when Gator's providing its second bid. Access had been provided to the site the prior December. December of 2012, access was obtained to that DSC site. Gator provided its second bid the following August. And Gator asked at the time it was supplying that bid to Westra, the second bid, has anything changed? And Westra said no, even though TECO and Westra both knew at that time that access was available to the DSC site. And Ms. Lyons testified, if I'd known that access was available to that site, I would have taken advantage of it.
But the chert was encountered under the South Fork of the Alafia River, correct?
That is correct, Your Honor.
Were there any core borings of the Alafia River?
None, Your Honor.
So none of these core borings matter.
Well, I disagree, Your Honor.
You had all the core borings that were done in the entire project, both before, after, and in the middle, and it wouldn't have told you about the rock under the Alafia River.
Well, Your Honor, the ASTM required the owner to do a detailed geotechnical examination and report. They chose to do the borings where they did. Our contention is the contract says the owner is obligated to do that analysis and provide it to the contractors. The second report was never provided to us. And I think that's, Ms. Lyons has testified that that was material to her. It's undisputed that Gator Boring would not have entered into the contract if she'd been provided with the second report. And so it was very important to her, even though you are correct, Your Honor, no bores were done under the river. Whether that's because from an engineering perspective you can't do it, I don't know. But you are correct that the DSC site was the site closest in proximity to to where the boring was going to be done, and the owner's engineer chose that that was the closest they could get to perform bores, and their own engineer said those bores were critical to being able to complete the geotechnical review. So, Your Honor, additionally, if you look at the case law, it is clear once TECO undertook to provide geotechnical information in the form of the first report, then it was incumbent on them under applicable law to provide full information. That would mean once they received the second report, even if it was after the bid, they were required to provide that second report to everyone. And it's clear my client never received the report until discovery in this case. Even when the issue came up, the rock was encountered, and 2 meetings were held, and discussion about how to proceed. And Gator was directed by TECO to proceed, and that TECO would make sure Gator was reimbursed its additional costs. Even at the time of those meetings, when the focus was on the rock that had been then experienced, the second report was not provided to my client, and nor was the crucial email warning the directional boring subcontractor of what would be encountered. That wasn't shared as well. None of that was shared until my client got the material in discovery. So it's also undisputed, as far as Ms. Lyons' testimony, during those meetings about how to address the subsurface rock that had been encountered.
And let me follow up, if I may.
Yes, Judge.
I've got both reports here. The first report says limestone was encountered, hard limestone was encountered, and it explained all that. The second report, if you look at the evaluation, pretty much says the same thing. Hard thing is encountered, and I guess to follow your argument, you said, okay, the first report, yes, and then you're taking the position that somehow the second report brought added information or surprising information. If you look at both of them, they appear to be pretty much the same. It's just saying, okay, it's more of the same at a location, to follow up what Judge Moore said, that is away from where your client ultimately did the drilling.
Judge,
help me out with that.
Judge, again, if I go back to the wording itself too, the first report says the majority of the borings performed did not encounter any deleterious material, shallow rock formations, or any other conditions that would make conventional excavation techniques, jack and bore, or directional drilling operations difficult.
But if you look at the very first part of the first report, it indicates that hard limestone was encountered. So it did mention.
You are correct. I'm just looking at what the evaluation said. And if you go to the second report, it says directional drillers will have to consider the harder material that will be encountered when drilling is conducted in this area. And I think that is distinctly different from what the first report said.
And then it goes back again to talk about the site of that in this area, the area that you're referring to, this report number 2. I mean, I've heard it categorized either 1,000 feet or 3 football fields away from the ultimate. Am I correct in my review of the record?
You are correct, Your Honor. The important thing is that was the closest boring information that TECO had obtained. It was never shared with my client, and my client, under oath, as an experienced drilling contractor, said if I had this report, I would not have entered into the contract.
Is that more convenience after the fact, considering that your client respectfully didn't hire an engineer at the very beginning, didn't do a lot of the things, to use Judge Morse's word, the due diligence at the front end, and then to somehow now, after the fact, say, oh, we wouldn't have entered because of this, and referring to a report that's really far away from the actual area where your client, how does that all weigh in?
But, Your Honor, it goes back to what did the contract documents require? And the contract documents in the specifications included this ASTM 1962. And what that ASTM does is puts the responsibility on the owner to retain a geotechnical engineer who is to do a detailed examination and prepare reports and information that is then required to be shared with the contractors for both bidding and subsequent installation.
And I have to interrupt you. You're about to get into your rebuttal time, so it's up to you. Do you want to continue on? Or
Just let me finish this point. So the contract required the owner to have a geotechnical engineer do a detailed analysis and provide it to the contractors. The oil report provided to Gator throughout this project was the first report, and it had the right under the contract documents to rely on that report. If the second report, after it was prepared, had been shared, which I think was required by both the contract and applicable case law, if you look at the Jacksonville Port Authority case, Longboat Key case, any of those cases say when an owner undertakes to make representations concerning a subject matter, here the subsurface conditions to be encountered, it has the obligation to provide full and complete information, which would have resulted in the second report being provided.
Very
Thank
good.
you.
So you have about 4 minutes left.
Thank you very much.
All right, sir.
May it please the court, my name is Charles Lane. I represent Tampa Electric Company. I think crucial to this appeal is the timeline that's established by the undisputed facts in the record. Because we're talking about summary judgment here, the undisputed facts I think are important. If you go back and look at what's in the record, in February of 2012, NODARS or Terracon completed that first report. And that first report didn't include test bores around the HDD site under the north prong of the Alafia River because Tampa Electric Company didn't have an easement from the owner to get in there. In May of 2012, there's a pre-bid meeting. At that time, Tampa Electric Company is asked, can we get in and look at the site? Do we have any bores for this particular area? They said, no, we don't have an easement yet. We don't have any bores. Do your best by looking at the site from the right-of-way and checking publicly available sources. In August of 2012, with that information as the only information available, Westra enters into a contract with Tampa Electric Company to build this 14-mile, I think it's a 14-mile pipeline for roughly $14 million. In August of 2012, so roughly 4 months after the contract between Tampa Electric Company and Westra is signed, the bores in that area that were not complete before are done. In February of 2013, Terracon, the boring company, tells AECOM, which is Tampa Electric Company's engineer, that the report's going to be done in a week. That's February of 2013, so we're now 6 months post-contract between Tampa Electric Company and Westra. In April of 2013, Terracon sends the second report to AECOM. So now we're 6 months post-contract between Tampa Electric Company and Westra. Excuse me, I missed a date in here. Yes, that's right. So we're April of 2013. July of 2013, Westra, not Tampa Electric Company, contacts Gator about replacing their HDD subcontractor. On July 30th, 2013, that first contact is made between Westra and Gator post-contract.
Gator had submitted a bid earlier on and was not the successful bidder.
That's correct.
So they had access to the information that was available at the time.
Right, but there hadn't been any communications between Gator and Tampa Electric Company, either pre-Westra contract in 2012 or before July 30th of 2013, roughly a year later.
But I want to make sure I understood what you said. The core borings on the private property, which were not available at bid time, became available sometime in the late spring, early summer of 2013.
That's correct.
Before Gator got involved.
Right.
Okay.
Right. Then Gator asked Westra, they didn't ask Tampa Electric Company, they asked Westra, have there been any additional borings done? Westra not Tampa Electric Company, tells Gator, base your bid essentially on the information that you had back in August of 2012 when you bid it the first time. So at that point, Tampa Electric Company's not been contacted by Gator, not made any representations of any kind to Gator.
And so you don't feel I mean, you certainly were aware that Gator was now being asked to do this after the previous subcontractor driller pulled out. Certainly there had to be knowledge at TECO that there was a pullout of the subcontractor driller, and Westra, your prime, was endeavoring to find another sub to do the drilling, and the sub they found was Gator. So you knew of them, right?
Well, actually, the record reflects that the first time Tampa Electric Company knew anything about Gator coming in as a replacement HDD was the next day, or excuse me, 2 days later, August the 1st of 2013, because the first contact between Westra and Gator was July 30th. On August the 1st, Westra tells Gator that its bid is acceptable, and then, excuse me, on August the 2nd, Westra tells TECO that Gator has been contacted as the replacement HDD subcontractor. So we didn't know anything about them until August the 2nd.
Well, between the time they were contacted, which I think you said was the 31st of July.
30th, yes.
30th of July, and they signed their contract on the 8th of August, correct?
They signed their contract on the 6th of August, Your Honor.
Not even a week.
Right, and on August, and the record reflects that on August the 5th, the day before Gator signed its subcontract with Westra, Tampa Electric Company forwards to Westra an email that it got from its engineer dated August the 2nd, so that's the same day that TECO found out about Gator. That email included a warning that the drilling contractor should be made aware that there's potential for encountering rock anywhere in this area of the state. So my client is dealing with their contracting party, Westra. They don't have a contract with Gator. They have been contacted by Gator, and they don't have any obligations to subcontractors.
You heard what your opposing counsel said when I asked him that question. He said basically that there was an adoption of the TECO contract in their subcontracting process.
There was between Gator and Westra, but my client's contract is with Westra.
Right.
And we have obligations to Westra, but we don't have obligations to Gator.
That's normally how it is, but
Yes.
I was just going to make sure there's something peculiar about this that would make it different.
No, I don't think there was. And then,
So no privity, no duty for anything. You didn't have an obligation to do anything with Gator, even though your engineer was concerned enough about this. He sent an email to Westra's president and basically warning her that there was rock in the area and that the driller should be warned. She extrapolated that information out of that email, communicated with Gator, but excised the part of the warning.
well, that's not exactly how it happened, Your Honor.
Okay.
TECO got this email from AECOM. TECO forwarded that to Westra.
Right.
So, again, my client did what they were supposed to do. They communicated that to the party that they had a contract with. Now, if Westra didn't communicate that to Gator, perhaps that gives some claims between Gator and Westra, but that doesn't create a tort that my client committed, nor does it create any breach of contract that my client is guilty of.
So then, even though in the summary judgment context, fraud is very factually intensive and subtle, and as rarely do you get a summary judgment on a fraud claim. I mean, our case law is pretty consistent with that. What I'm hearing you say is that doesn't matter in this context because there was no duty under any scenario that TECO had to Gator. So,
Well, maybe more importantly, for the fraud claims, there's no false statement that Tampa Electric Company ever made to Gator. Fraud, either fraud in the inducement, fraud in the performance.
You had some verbiage at the time the rock was encountered, and the equipment was broken, and you were so concerned about the frac outs that you hired somebody to do the cleanup, and obviously there was a serious problem now that had been encountered by Gator in drilling this pipeline, that you said a lot of things to them that led them to believe they were going to get paid. If they, irrespective of whatever, I mean, the way I read this, you sure urged them on with sort of subtle promises, we're going to take care of you, just keep drilling, we're going to take care of you.
Well, remember though, Your Honor, they didn't encounter this rock until December of 2013, which is 4 months after they had a contractual obligation to complete this drill.
It's pretty early in the ballgame.
Well, it's when they're doing their work.
Yeah.
But fraud in the inducement, I mean, their counts are fraud in the inducement. That means that we induce them to get into this contract by some false statement. Well, they signed this contract in August of 2012, and they never had communicated with Tampa Electric Company in August of 2012. We couldn't possibly have made any false statement. We didn't make any statements to
I
them.
understand the fraud and the inducement to enter the contract, but how about the fraud associated with them continuing in a situation that clearly was not consistent with the information they were provided to bid this contract?
Well, their claim is not, you defrauded us by demanding that we do what we had a contractual obligation to do. Their claim is, you defrauded us by hiding from us these bores and this information. Well, the bores weren't done until 4 months after they had a contract.
But before they hit the rock,
But
about the same time.
they're already under contract. They already assumed the risk. They said, we're going to bore through there. We don't know what's in
I
there.
understand all that, but don't you think that if you had provided it to them, even they were in the contract, they may have said, ooh, we got some rock coming up, we better use different equipment, we better get ready for this and adjust our game plan? And you really didn't give them a chance to do that. They just ran smack dab into the rock and wrecked their equipment.
But again, Your Honor, we don't have a contractual relationship with a subcontractor. All we have to do is communicate with our contractor. And we told the contractor what was going on out there.
Yeah.
If they didn't pass it down to their sub, then maybe it's shame on the contractor, but it's not shame on Tampa Electric Company.
I understand.
And when we get to those meetings, they come in December and say, hey, this is a lot harder than we thought it was going to be. So they have a meeting in January, they talk about it, they submit a formal claim for extras, and in February, my client writes back and says, I'm sorry, there's no entitlement to extra payment.
But you didn't say that at first. Your people didn't say that at first. Your people at first said, hey, you know, we know you've encountered some things, and you're getting a better drill than you're being paid for, or we're getting a better drill than you're being paid for, but we're going to take care of you, so keep drilling.
Well, we didn't get a better drill than we paid for. We paid for a drill.
I don't know what you got, what you didn't get, but
Well,
I know one of your employees said that.
So we've got a low-level employee meeting at the site to talk about these extra costs that they want to get paid for, that they don't have a contractual right to get paid for, and he says, keep track of your costs, but keep drilling. All that is consistent with, you do what you're obligated to do by contract, we'll take a look at it and see if you're entitled to any adjustment. Well, we're all bound by the terms of the contracts we sign.
And this is what I think the focus needs to be put on, is that what are, and you started with that, Mr. Lane, what are the undisputable facts in this case? What is TECO's duty? What's TECO's obligation under this unique thing? And by outlining everything in terms of some of the claims that have been brought, the tort claims, there's cases that have addressed that and indicating, okay, they may have against Westra, but again, we're dealing now against your client, against TECO. What are they able to show against you that's a material issue of fact that would preclude the entry of summary judgment? That's what we need to focus on.
That's exactly right, Your Honor. And the tort claims, they say that we were somehow negligent. Again, that all goes back to what did we do before they signed the contract. They're not saying that we were negligent during the performance of the contract, and that's all determined by what the terms of the contract are anyway. All their fraud claims say we committed some fraud because we didn't tell them that there was chert underneath the Alafaya River. But we didn't make any false statements because we didn't make any statements to them, so there can't possibly...
You didn't know, did you?
We didn't know.
I don't think anybody knew.
Nobody knew. And in fact, Your Honor, you know, chert, as the record reflects, and I don't know if you got in there far enough to see it, but chert is actually quartz.
Yes.
Or it's some quartz derivative. Well, neither report talks about quartz. Neither report talks about chert. They both talk about limestone. And
does that matter that much, though?
I don't know.
They're both hard substances, they're hard to drill through,
And they knew that there was hard stuff out there
Yeah.
before they signed the contract. And they signed a contract that said you don't get any adjustment for obstructions unless it's a man-made obstruction. So the fact that it becomes more expensive to drill through that rock than they thought it was doesn't mean that they get to any sort of an adjustment in their contract. And that's the position that my client took consistently. When they had the meeting, they write a letter and say, nope, we're not paying, we're not obligated to pay for it. They come back about a month later and they talk about it again, and there's some talk about the costs, and there's some talk about splitting the cost three-way. Well, okay, question about whether or not that person who's a lower level employee can make that sort of a representation. Clearly you can't make it for AECom and Westra, but they don't say, we got a deal, we'll take the cost. We've got an oral contract, which is one of their claims later on. They don't say, we've got an oral contract, we'll just take the cost, we'll waive overhead and profit. No. Then they send another letter to Westra and say, send this to Tampa Electric Company and ask them to pay us for the cost, the overhead, and the profit. And my client writes back and says, no, you don't have a contractual right to it. That's a risk that you assumed when you signed this contract with Westra 1 year after we had a contract with Westra where Westra agreed to drill through underneath the Alafia River without knowing what's underneath there. So my client didn't do anything except insist upon performance of the contract. And they had a right to insist upon that with Westra, and they didn't have any obligations to subcontractors. I think all the cases that they talk about obligations between owners and contractors. I don't think you'll find any of them talk about obligations of owners to subcontractors. And effectively, their complaint is that they are stepping into the contractor's shoes in those cases, and Westra ought to be treated as the owner. And they're really saying Westra knew that there were bores done out there, and they bamboozled us when we signed that contract by not telling us. That's not Tampa Electric Company's fault, and I think that's why the judge granted us summary judgment. That's what I think ought to be done here, is that ought to be affirmed, because my client didn't commit fraud, my client didn't commit a tort, my client didn't breach a contract. My client just said, actually my client said, you Westra do what you're obligated to do, which is build this thing, and if that's because you went out and found Gator to do it, so be it, but that doesn't mean that we, TECO, have to pay more money for it. And so all we're asking, and all we've ever asked for, is to have that pipeline built for $14 million, which is what we paid for and what we got. We didn't commit a tort, we didn't breach a contract, we didn't enter into any oral contracts, there wasn't any implied in fact contracts because there was already an existing written contract. And so summary judgment was appropriate. Whether they've got a claim against Westra, different story, but they don't have any claims against Tampa Electric Company.
Very good. Thank you, Mr. Lane. Okay. Mr. Manuel, you have about 4 minutes for rebuttals.
Thank you very much. And I want to focus on, Judge, what you raised, and that is what's undisputed, what's disputed. And clearly, when we get to the point where the rock has been encountered and these meetings are held, there are issues of fact about what was discussed and what was agreed to.
I guess I'm trying to find out what is their duty? What is the duty? Because you're dealing with TECO. We're not dealing with Westra. And
Judge,
I grant you that for Westra, I could understand. TECO provided everything they had to Westra. And now we're looking at all the cases regarding these things. And a lot of the cases you cited is what Mr. Lane said, deals with a contractor and with their own. So here we're dealing with a subcontractor who's jumping over going to the actual owner of the property. That's where I'm having difficulty.
Well, Judge, but when the rock is encountered and these meetings take place, TECO, TECO's engineers, Westra, Gator, everyone's in that room. And that is when Ms. Lyons has testified under oath in 2 of those meetings. The TECO project engineer, not a lone employee, a project engineer said, okay, keep track of your costs and we'll make sure you get paid. Ms. Lyons testified that was discussed in both meetings, and representations were made, and that Gator relied upon those representations, which were made directly by TECO to Gator. And Gator relied upon those, and that therefore proceeded with the work. The trial judge, we believe, improperly granted summary judgment, basically saying, when I look at these two TECO letters, I get to ignore Ms. Lyons' testimony. And at best, if you look at the letters, they're not sworn. Her testimony is sworn, and those letters do not rebut that discussions were held and agreements might have been reached. The other inference you could draw is, Judge, just what you indicated, which is TECO made representations to induce Gator to proceed with this work. Gator did so in good faith, tracked its cost as directed, submitted those costs, and then after the work was done, then TECO in a letter said, well, we've changed our mind, we're not going to pay you even though we represented to you we would.
Well, let me go, because you've made a claim for fraudulent inducement. And so going back, aside from these discussions, something fraudulently, and you're making the reference that it's that report that was fraudulently kept away, and leaping that into the fraudulent inducement, how does that parlay under the facts of this
Well,
case?
Judge, I think clearly, putting aside whether there was a contract between TECO and Gator, clearly when we get to the meetings when the rock has been encountered, that second report should have been disclosed at that point. Whether there's a contract or not, they're all in the room. They're talking about how do we address this rock that's been encountered, and the second report was clearly crucial to that. And yet, neither TECO nor Westra, even at that point, when we're dealing with what has actually occurred and been encountered, did not share that report. And I think at that point, TECO was dealing directly with Gator, and I think at that point, TECO did have an obligation to make full disclosure of that report. Keep in mind that, the prior August, TECO's engineer had told Westra, hey, Westra, you better warn your pipe contractor, your drilling contractor, that they're going to encounter rock. So TECO knew that a warning should have been given to Gator the prior August. Was that given by Westra? No, it was not. Flash forward to the following February and January.
We're getting close to the end, if you want to wrap it up here.
Where the rock has been encountered, then you have the direct discussions, and on the various theories, we think clearly there's an issue of fact and summary judgment was not proper. Thank you.